Broadcasting from the world headquarters of the National Floor Safety Institute is America's slip and fall guy, Russ Kenzie.
This is America's Slip and Fall Guy, Russ Kenzio. Thanks for listening to my podcast.
As many of you know, this subject of slips, trips, and falls oftentimes leads to litigation, a lawsuit. People get hurt at a grocery store, retail store. They get hurt at work. They get hurt anywhere, and they feel entitled to file a lawsuit, hire an attorney, and take them to court. Today we're joined by a attorney by the name of Charles Dunkel with the firm of Mills Shirley out of Houston, Texas. Is that correct?
Originally in Galveston.
Originally in Galveston.
Our main office is still Galveston, but we do have a Houston office.
Got it. And I know you cover a big area, but you've been a defense attorney for how long?
Well, my career started in 2001 as a prosecutor.
Oh, wow.
And then I did that for about 3 years and eventually went into the civil world and started defending companies.
So Mills Shirley, been around for a while. You've been an attorney for a very long time. And you do primarily or exclusively defense work, right? So you're a defense attorney. And this subject comes up quite a bit, I presume. Slips, trips, and falls?
Comes up a lot because I do personal injury defense, as you indicated, just representing companies.
And give us an example of types of companies. Restaurants, what kind of grocery stores?
You name it. Yeah, grocery stores, small convenience stores, trucking companies.
Wow.
You got to realize that the majority of my cases come from insurance defense.
Right.
Most companies are not self-insured, so they take out a policy. Part of the agreement is, if a claim is filed against you, the insurance company is going to handle that for you and defend you, indemnify you, which includes the use of their attorneys that they have on a board. And so most of my cases come from insurance companies.
So walk us through the process. You get a call from a client that's an insurance carrier, and they say, Charles, we had we need your help on a slip and fall or a trip and fall that took place at a particular location. Kind of walk us through, how does it begin? How do you get engaged, and how does the process work?
Well, the process begins on the other side of the plaintiffs. They believe they've been harmed. Usually, they contact an attorney. Attorney files what's called a petition, which puts the defendant on notice of, hey, you harmed my client. We're saying you harmed them to these facts as we know them right now, which was a violation of the law, and that's filed. And then if you're insured, if you're a company that's insured, you immediately turn that claim over to the carrier, and the carrier will get in contact with me. Everything's forwarded to me. Usually, if you get sued, you have some notice before this lawsuit came anyway. Dealing with just slip and fall cases, or I do a lot of car accident cases too, defending car accident cases. If there's been a wreck, chances are you're going to be in a lawsuit, especially if there was an injury. So you start gathering, as a company, you start gathering up information, evidence, preparing your defense, even though you might not realize that's what you're doing. You start early on doing that. So by the time it gets to me, there's already somewhat of a file put together that's passed to me. I review it, and I start I get with them and begin getting additional information I need in order to protect them and start building up a defense and asserting those defenses, and file an answer saying, it's your responsibility, plaintiff, to prove that we did what you said that we did.
Right.
And
the burden of proof is on the plaintiff.
Absolutely.
The defendants don't have to prove they did everything right. The plaintiff has to prove they did something wrong, and that led to the person's injury. On the flip side, how does a plaintiff attorney get their cases? How does it work for them?
Well, I'm not a plaintiff's attorney.
But you work enough with them.
Never have been. I'm going to say it's probably a lot of, other than the advertisement that you see on a day-to-day basis, whether it be radio, TV, advertisements driving down the road with the billboards. Probably a lot of it's just word of mouth. I don't know how much time, because it doesn't come up. I don't ask how much time a plaintiff took to do their due diligence on finding the attorney they end up retaining. But it's probably just word of mouth, or they had a family member who used a certain attorney or a friend, and they got referred over to them.
I can't tell you how many times I've heard defense attorneys say, without plaintiff attorneys, they wouldn't need defense attorneys. I mean,
That's right.
It's the nature of it's the nature of the business. And we're in America where people feel, and they have a constitutional right to a jury by their peers. So it's common for us to have a high number of lawsuits, not just slips and falls, but all lawsuits because of our constitutional right. I travel around the world and cannot tell you how many times I hear, well, you Americans and your lawsuits, these frivolous lawsuits. And, our Constitution provides us that remedy where other countries simply don't. And whether it's frivolous or not, I guess, is up to the jury or the judge to decide. But so you get engaged.
Yeah, it'll work itself out.
Yeah, it always does.
Absolutely.
It always does. So you get engaged by a defense attorney representing an insurance company. As far as the payment process, I know it's different how defense attorneys get paid versus plaintiff attorneys. Kind of explain how that works. How is it different, or how is it the same?
Well, with regards to the plaintiff side, the majority of the cases I deal with, I know that this is what's called under a contingency fee arrangement, where the plaintiff's attorneys will front all costs of the litigation in return for a percentage of any reward that you receive, whether it be a settlement or through the verdict. I'm sure there are times where plaintiffs' attorneys do hourly work with their clients, but for the most part, on personal injury cases, I just don't see how that would be so really viable or a good business decision. I mean, you would. But the plaintiff's attorneys, and for the ones that I've dealt with, they do their due diligence up front too. They take their time, they get these cases in, they see if they're frivolous or not, and
Right.
And see what's the risk benefit analysis. What's the chances of recouping some of your cost and getting a percentage of an award. They go. The ones I deal with for the most part do that. Now there's those out there that don't.
Sure.
Whatever walks through the door, they're hiring and they're running with it.
Right.
And there's no due diligence up front, and we learn that throughout the case.
Yeah. Well, oftentimes those attorneys find different lines pretty quickly because it's their money. If they're going to invest a lot of their energy and time and money in what I refer to drilling a dry hole, because I get calls frequently from attorneys who present a case to me, and it just, again, it's just not a case that I can help them on or provide any level of assistance. And it's just such a, these are hard cases to win, even when you have a good case. Slips and falls are not easy to win. Would you agree?
I would agree with you wholeheartedly on that.
They're really tough. And juries across the country, regardless if you're in Texas, which is a conservative state, generally speaking, outside of our major cities, jurors don't really find in favor frequently, at least in large cases, for plaintiffs, which again goes into the mix of why a plaintiff attorney may want to turn a case down. But on the flip side, and you and I have talked about this in the past. Insurance companies were very willing to pay claims. They would just, it's cheaper to pay a plaintiff off than to deal with the cost of litigation. Is that fair?
Yeah, I think over the years that I've been defending these cases, I've seen somewhat of a cycle. When I first got involved in it, I think that you're right. There was a lot of, they would just, they would pay cost of defense. We're going to pay X amount on this to defend this. We'll use that money to settle the matter. And which promoted more of those type of cases, whether if they were frivolous or they were legit. People knew, hey, if I bring this claim, I know I'm going to get paid. And then I did see a turn where the insurance company said, no more of this. We got to start fighting. We got to start pushing back because there's just too many frivolous suits amongst the ones that are legit. And I've seen that pushback. And when that happened, these cases were dying early on the vine. They didn't go very long. There wasn't a lot of discovery, and it was just as if they could get a little bit of something, they would take it.
Right.
But I see our communities, the way our communities, especially in the bigger municipalities, where we're getting back to, I should say, these cases are going further. They're starting to get in front of juries. There was a time, probably a good 5-year stretch, 5, 6, 7 years. I didn't get anywhere close to a jury trial on slip and fall. We settled them really early. But these are starting to get some traction. They're starting to get in front of juries, and the juries are starting to give some pretty decent awards on these. And I think it has a lot to do, again, with just our communities changing, becoming more liberal. I think you had indicated, the bigger populations are becoming more liberal. You can get bigger awards. Where if you go out to rural areas, it's more conservative, and those areas it's still hard to get cases to a jury. But these cases come down to 9 out of 10 times is someone thinks they fall for whatever reason, and it comes down to the reason for the fall was it open and obvious. That seems to be my argument every day with these cases. Was it open and obvious?
Meaning the defect or what caused their
right.
fall?
What they're saying caused the fall, whether it be there was a liquid on the floor, or a planning border was damaged and sticking out, or a building was designed wrong, and there's a step that should have been marked, highlighted in red or yellow, or to signify it, because otherwise it's camouflage and you can't see it. And it just comes down to was it open and obvious?
Right. Now, when you're working with an insurance carrier and you get a case and you're like, boy, this is when they really just need to pay. I mean, it is a legitimate, argument. And I know that in the past, you and I have talked about this. It's just, professionally speaking, hey, we really can't help you. Just sort this one out and pay a claim. And there's cases that you simply say, no, this is kind of defensible, and we want to take a strong defense. But good lawyers do that, right? They sort it out pretty quickly.
Right.
The stereotype of the ambulance chasing attorney, and there are some out there. I've worked with a few, but most are not, Charles. I mean, most are professionals.
Correct.
They're business people. They're very well educated and well trained. They do their homework. They don't want to take a frivolous case. Sometimes they do. They don't know it's frivolous. And that's where experts like myself come into to play to help sort that out. But how many cases what percentage would actually settle versus going to trial?
Oh, large majority.
90% more?
I would say higher than that. I would say, yeah, it's 95 to 98%.
Does that include?
We get them settled.
I know there's this arbitration, mediation. How does that work?
Well, arbitration and mediation are two different forms. Mediation is where it's very informal. You meet with the mediator. You kind of tell the mediator, hey, this is our perspective of the case. These are the case issues. These are our case defenses. This is the issues they're going to have if we go to trial. And the other side does the same thing. And by that point, you've worked the case up. You pretty much close. You're pretty much finished with discovery. Depositions are pretty much completed. So you know everything that's going to come out during trial, everything that's going to be said. And so you kind of break that down at mediation, and you just start talking numbers. Sometimes the liability issue dictates at the mediation, what, like on the defense side, if we think there's no real liability, our number's really not going to get high on a settlement. But both sides know that before we show up. On the other hand, I have cases where I know we're going to be writing a pretty substantial check, and again, both parties know that when we go in, and so the mediators, they're trying to work this out. Trying to get both sides to compromise, and using the strengths and weaknesses of a party's position, for them or against them, going back and forth to two different rooms. And Hey, I don't know what my percentage is of success at mediation. A lot of times we settle there. A lot of times it gets settled, but the mediation was just a part of the settlement process. We didn't get it settled there, but 2, 3, a couple of months down the road, we do. And the mediation process did help get us to that point. It's just that day it didn't happen.
Right.
Arbitration is more formal. You have an arbitrator who's acting as a judge, and you're laying out your case to him just as if you're in a courtroom with a judge or jury. And the rules of evidence are pretty lax. That's the one thing I don't like about arbitrations. It's everything comes in, the ones I've dealt with. There's really no gatekeeping taking place at all. The mediator gets to hear all the good, bad, and all the mudslinging. And then he goes off and he writes an opinion and makes a decision.
Now, is that mandatory? Is that court ordered?
It depends. Usually it's contractual, so it's in some agreement. Like a good example is a lot of, you take employment at a company. Part of your employment is you sign an arbitration agreement. You end up suing the company for whatever reason. You're off to arbitration, you go. Right. Based on the agreement.
You mentioned a moment ago about open and obvious, and that's a legal term. I'd like you to spend a little bit of time talking about that. And really, how does that affect negligence? When somebody says, you were negligent, or I'm filing a negligence lawsuit, what does that mean?
Well, with regards to negligence, when we all go out into the world, the standard that we all have to live up to is you just be prudent. Be a prudent individual, and act prudent in all your conduct on a daily basis. And so, if you sway from that being prudent, and you hurt someone, usually it's because you were negligent. Like if I'm following you we leave here today, and I'm following you in a different car, and you slam on your brakes, and I'm just not paying attention. I hit you. I had no intent to rear-end you that day.
Right.
But because I wasn't paying attention, I was negligent. I wasn't being prudent. I'm driving a vehicle. I need to be watching what's going on all around me. What's my speed? What's going on beside me? What's going on in my rearview mirror? What's going on in front of me? It's part of responsibility that we take on when we get our driver's license. And then if I don't live up to that, well, I was not prudent when I rear-ended you. I was negligent. I think that's as bare bones I could probably make that.
How does that work for like a slip and fall? Give an example of, somebody's going into a restaurant or grocery store. They're shopping. They're not looking at the floor. They're looking at merchandise or whatever it might be, looking, where the hostess is about to seat them, and they come upon an unexpected hazard on the floor, causes them to slip and fall. They get seriously injured. How does that spell out as far as the prudence, the reasonable care?
Yeah, well, when it comes to let's just take a grocery store, for instance. Excuse me. And something has spilled. You get into the responsibility of the store with regards to how quickly they have to get that cleaned up. Well, number one is they got to get notice. There's something on the floor that needs to be cleaned up. What's a reasonable time to have notice on that? I mean, if you're in a really busy store and I knock down a bottle of ketchup and it breaks all over the place and the store is busy, well, I would assume that you get noticed pretty quick, and the next thing you know, clean up on aisle 3. Should that? If the store's busy, that should happen pretty quick. And you got workers working different aisles, talking, doing maintenance and all that. So I can't sit in every case is going to be different with regards to what would be a reasonable time period. But that's the first thing you have to look into. Well, were they reasonable with time they got noticed and cleaned it up? And if, again, case by case basis, you listen to the scenario. What if it was a store, it's a mom and pop store in the middle of Beat-Eye, Texas, okay? And they're lucky to get 5 customers in that store at one time.
Right.
And I'm the one customer that's in at the 10 o'clock hour. I knock something off. I don't tell anybody. But no one comes in for 3 hours. And there's all the maintenance has been done. And, the store looks immaculate. And there's just nothing else to stock. And then someone comes along 3 hours later and slips and falls on it. Well, hey, it was 3 hours reasonable in that situation? It just depends. You'd have to get more
Right.
more facts about what took place. But that's a good example. I mean, that would probably be too long. 3 hours, come on, walk your store, But, if mom and dad are the only ones running it and dad's dealing with the air conditioner went out and he's dealing with that in the back and, mom's watching the front of the store, someone coming in is not trying to steal, maybe 3 hours could be reasonable. I'm really stretching it here,
Right.
but I think you get my point.
No, and we'll be talking about this later, but that's where expert witnesses come in. That's why, as I like to say, God invented experts as they have attorneys is to really kind of spell out what is reasonable, because that's a phrase that's used both in your profession as an attorney and mine as a safety professional. Is what's reasonable? Is 3 hours reasonable? Is half hour reasonable? And there's the difference between a Walmart supercenter and a small local market.
Absolutely.
But yet there's standards of care that are used to define negligence. Stop me if I'm wrong. Negligence is the failure to provide reasonable care. So it kind of sorts itself out as what was considered reasonable
Under those circumstances.
Correct.
I think that's really key. You have to say that.
Right.
Under
And
those circumstances.
And that's it. Every case is different.
Absolutely.
So oftentimes people will say, hey, I was at a grocery store. I slipped and fell. I got hurt. And I'm going to file a lawsuit and make $1 million. The reality is just because you slipped and fell doesn't mean it was negligence on the part of the defendant. And it doesn't mean you're going to get anything. In fact, many cases, as we mentioned a moment ago, these are tough cases to win. Most of the time, plaintiffs don't prevail. And again, there may be an injury related, but that doesn't mean you're owed something.
Correct.
And that's a misperception. I don't know if you hear it in your profession. I certainly do. It's a misperception by the general public that just because you were hurt and you hired a lawyer and filed a lawsuit doesn't mean you're going to get anything. I mean, you can walk out with a whole lot of nothing.
Correct. And that does happen a lot. Or you just walk away with what's called nuisance value.
Right.
Again, depending on the case would dictate what's considered nuisance value. Most of my cases with slip and falls, I'm at least dealing with $100,000 in damages or injuries and the cost of the treatment for the injuries and future costs to take care of your rehabilitation. And nuisance value in that type of case could be $5,000, $10,000, maybe $15,000. But if it's a legit case, legit injuries, and because I've had cases where I had close to $750,000 on slip and fall, and it was 100% legit damages. I mean, there was several operations. There was going to be several more operations in the future. We were dealing with an organic brain injury, and nuisance value in that case.
Going to be high.
Yes, definitely it was going to be higher. Believe me, we did not settle that case for nuisance value. I mean, it was that was one of the rare cases where I was concerned about gross negligence on part of my client. I mean, which in these cases you really don't get into.
Yeah.
I mean, it happens, but not a lot.
Yeah. Well, we're going to be carrying this conversation on to part 2 of our second podcast, and we're going to talk more about some of the stories that you have to tell about cases you've been involved in, perhaps your firm's been involved in, and really, where's this all headed? How is this going to be sorting out? You mentioned a moment ago that more of these are going to trial, and there's larger and larger awards, jury verdicts, awarding larger sums of money. So
yeah, and I think it's just two reasons for that. Number one, I think the insurance companies are pushing back again. They were paying out a lot of just the nuisance value, and I think they're getting tired of that, and they're pushing back and they're saying, no, let's just go to trial. And I think the other reason is what we've already talked about. I think because these are starting to get in front of the juries, and the juries are starting to give decent awards on these, those two factors are really gaining a lot of traction, and these cases are going forward and getting a lot further than they ever did before. What's
a average cost to defend a slip and fall case? I mean, how much if you're a grocery store, you get sued from beginning to end, assuming putting aside the verdict, if there is any settlement, just the legal cost, the cost to hire you, your firm, to defend from start to end.
I would say the average, and that would be just considering probably maybe a couple of witnesses, 2 experts, one on each side. I would say the average is about 100 to 125,000
total for both sides.
No. Just to defend it.
Okay,
to
so
defend it.
100,000 plus, and bigger cases obviously are going to take more time.
Absolutely.
Well, what's an average time
For the whole lawsuit from
Yeah.
beginning to end,
Yeah.
I would say to work a proper case up, to work a case up properly and get to mediation. And settlement mediation is probably, I want to say it's about 18 months
Okay.
to 2 years. And if you want to go to trial, that's going to be dictated on what jurisdiction you're in. If you're in Harris County, say, you're probably not going to get to trial within 2 years.
Right.
If you're in a smaller area, you probably can. But I want to say that the lives of my cases, I want to say we get them in and out probably within 2 years or less.
And that's not, and Harris County, by the way, is Houston, Texas.
Correct,
So
right.
That's not going to trial, or that includes trial?
No, I would say that's not going. 18 months not going to trial. A good 2 years if you go to trial.
And that's going to be even more expensive to.
Oh, right.
So it's going to push the number up even more. So say you're a big grocery store chain. You have, sadly, a lot of claims, a lot of slips and falls. You have a large number of slip and fall lawsuits. You're counting 150,000 to defend yourself, assuming you're not paying a settlement or a large jury verdict. So this can become really expensive just on defending
Absolutely.
yourself. And on the plaintiff side, I assume the cost would be high as well, because they have the burden, so they have sometimes even more costs to.
Yeah, I found that usually my cost is pretty equivalent to theirs.
Mm-hmm.
I mean, they have let's say we get to where we're going to settle a case. They have the burden's the wrong term. They can go back to the providers and see if they can get the providers to come down off of what's owed to them. Providers meaning the medical providers.
Right.
And but other than that, I want to say the cost is pretty close to the same.
I remember
both
a
sides.
case I represented a defendant grocery store chain, and after the trial, which I testified at trial, the officer, the corporation, came up to me and thanked me for my help on the case, and he said, we appreciate you helping us win the case. And as an expert, I don't really, as you know, I don't have a dog in the fight here. This is not a win-lose for me. It's just, my testimony is what it is. And I said, well, gosh, it kind of struck me, Charles, that he said that, helping us win the case. I said, win, you spend hundreds of thousands of dollars defending yourself. And if that's winning, what's losing? It's a lot of money to win. Right. And I said, well, what's your prevention strategy? How do you prevent these lawsuits in the future? And he looked at me odd. He said, prevention strategy? We don't have a prevention strategy. He said, we simply pass the cost along to the consumer. We charge, I'll never forget, 2 cents per pound for bananas extra, to pay the claim. And I didn't know this, but bananas are the number one volume seller in a grocery store. The mentality was, we pay the claim, we pass the cost along to the consumer, they pay a little bit more, and here was the punchline. He said, and we blame it on the trial attorneys. In other words, let's demonize the lawyers.
Shoot, why not?
Yeah, hey, it's the American way, right? Blame the lawyers. But it was an interesting answer, because you see, it's really a business model. The business model is people get hurt. We have insurance. In fact, that's another thing I hear really all the time is, insurance, we have slips and falls all the time. That's why we have insurance. Well, as you know, your carriers don't appreciate that sentiment of just, pay claims because, what the heck?
Right.
No, you don't want to have injuries. You don't want people to get hurt. Nobody wants to go through all that, except, attorneys. So don't get me wrong. They're, you're in the business of defending these cases, and plaintiff attorneys on the opposite end. One last question. Civil lawsuits can be filed in either a local district court or a federal court. I've been involved in both sides, and frankly, from my perspective, I find that the federal courts when they're presented with a slip and fall, they usually just don't like them. They find every reason in the world to kick the case out or knock experts out, to really discourage going to trial, and really, I guess, positioning the case in such a way that the plaintiff and defense attorneys just sort it out. Is that a fair assessment?
Yeah, I think you're right. They don't get a lot of those type of cases, though.
Right.
Most of those are going to be in your state court. To get in federal court, you usually have to have diversity, which you don't. The parties are not from the same state, or it's got to be a federal question. And your standard negligence case of walking in a store and slipping and falling is not going to raise a federal question.
Right. And I've actually been presented with that in a few cases, federal cases, that I was retained as an expert, where the judge will say, there's just no need for an expert. We don't need experts here. This is cut and dry. We can sort it out on our own. And I guess in some cases there's Dalbert challenges for experts, and there's a real process for which experts have to qualify. I've served in many of those cases, but I find that most of these slip and fall, trip and fall cases are filed locally in a county court or a civil court, a district court, and that's where the majority of these kind of seem to percolate, where you're drawing upon a local group of individuals to serve on juries. Is that the same experience?
You're right, and because that's who's going to have jurisdiction. Like I said, unless you trigger that federal court based on those two prongs I just mentioned, you're going to be in either a county court or a district state court.
Right.
Which, if I was a plaintiff, that's what I'd want to be. I believe being in federal court as a plaintiff brings your damages down. You have to recalculate your whole damages model, where you don't have to do that such in the state court.
Right. Well, sometimes it can be a complex maze, and we're going to carry this conversation on to a second podcast. But I want to thank you for coming in today.
Oh, thank you.
And
enjoyed it.
Filling us in on how the legal process works related to a slip, trip, and fall case. So thanks again for coming in, Charles. This is America's Slip and Fall Guy, Russ Kenzior. Thanking you again for listening to my podcast. And as a reminder, make sure your next step isn't your last step. Take care.